business owners. My name is Dana Ball. I'm a small business attorney here in the state of Utah, and we are just trying to help you business owners face reality and get you out of your comfort zone so that you can protect your business from the risk of liability. I used to be a litigator. I used to represent employees and sue businesses just like you. I don't do that anymore, but my focus when I was a litigator was suing companies for sexual harassment, discrimination, wage and hour, any employment type of claim. That's what I did. And what I have found is that a lot of business owners do not realize that there is more to a hostile work environment claim than sexual harassment. And that's what I want to focus on with you today, because I want you to know exactly what I'm talking about when I say hostile work environment. Is so important for you to know so that you can understand what's going on in your workplace. You can identify issues early because you now will have this knowledge, and you'll be able to get your handbooks and policies written in an appropriate manner so that you can train your team on what a hostile work environment really is, because it is not just a sexual harassment claim. And it's the most common that we hear about. And I just find that people automatically assume that when I say and talk about hostile work environment, that I am talking about sexual harassment claims. And I just want to clear the air that that is not what we're talking about. So sexual harassment, because of the Me Too movement, it is, boy, it's a hot topic today. So I want you to just put out of your brain sexual harassment claims, because I'm not talking about sexual harassment at all right now. All right. Hostile work environment. This means that one of your employees can sue you for a hostile work environment based on protected conduct. So what is it? If it's not about sexual harassment, what is it? Well, your policies, your training must be broader when it's talking about hostile work environment than just focusing on sexual harassment. It must include the other protected conduct. All right. Harassment is a form of discrimination that violates Title VII. It violates Age Discrimination and Employment Act, the ADA, and others. There are state laws. In certain states, harassment is defined differently. It could offer more protection than the federal laws. So you really need to get some advice from an employment attorney in your state where your business is. All right. Harassment is unwelcome conduct that is based on race, color, religion, sex, which includes pregnancy discrimination, sexual orientation, national origin, age, disability, genetic information. Okay, so harassment is unwelcome. I'm not going to get into what unwelcome means. I want to just stay focused on what a hostile work environment means. All right. Conduct for a hostile work environment claim must be severe enough that a reasonable person would consider that conduct to be intimidating, hostile, or abusive. So that's what you need to be aware of. If the conduct that you have, you've received a complaint from an employee, or one of your supervisors heard some employees talking about a situation that occurred, that puts you on notice that you need to respond, you need to act quickly, you have a duty to start an investigation, and so you're looking to see if the conduct is severe enough that a reasonable person would find it intimidating, hostile, or abusive. So this means that a petty slight, an annoyance. You know, there are coworkers that annoy each other. There are supervisors that annoy their employees. Or isolated incidents. Unless it's extremely serious, it won't be considered illegal. You are really looking at the situations that you need to be nervous about, right? You need to address every situation, but the ones that you really need to be concerned about that could go as far as a lawsuit would be the offensive conduct that is not an isolated incident. So we're looking at how often was it happening? What's the time period? You know, was it a one-time joke that happened 3 months ago and it's never happened again? Was it inappropriate conversations that's happening next to an employee's cubicle on a daily basis, and that employee has to hear it because they sit right next to the two people that are talking inappropriately? You know, what is going on to prove that it was severe enough? So offensive conduct will include jokes, slurs, name-calling, threats, intimidation, insults. It could be offensive objects that are brought to the workplace. It could be pictures that are shown, passed around, emailed around, interference with work performance. So you have to focus in on the severity, how often, how egregious was it, and what type of conduct was happening. Okay, here's an example, and I'm going to use the protected class of race, all right? So let's just say that you have that cubicle example. You've got somebody that is in has a particular race that is different from maybe the majority of your employees, and you've got two employees that sit next to that their cubicle is next to this individual, and they, for some reason, are not being appropriate, and they are maybe making racial jokes, which to them maybe it seems naive, but their meaning can hurt that person next to them, even though they may not know for sure that that person can hear them or is actually listening. That does not matter. What matters is that person did hear it, and they feel uncomfortable. They feel that the jokes were severe enough that it was intimidating or hostile or abusive. All right, maybe they were making racial insults. They could be calling that individual particular offensive names that are typically used to offend a certain racial group. Maybe they're showing intolerance of differences. They can pick out certain physical characteristics related to that race. They could and pick on that. So someone can feel that they have experienced a hostile work environment that has nothing to do with sexual harassment, but it is based on protected conduct under the law. So you look at the severity, you look at the frequency. One time or even a couple of times may not rise to the level of illegal action. So my question for you to end on: do you train your employees, and especially your supervisors, on what behavior is illegal? Prevention is the best way to eliminate harassment in the workplace. If you need information about a convenient way to train your team online, we'll put a link in the description of this video for you to check out. Thanks for joining us today. We'll see you next time.